Hi, I'm Kim Rubenstein. I'm a professor of law at the University of Canberra, and I started teaching constitutional law in 1993.
And hi, I'm James Blackwell. I'm a Wiradjuri man and research fellow at the ANU and member of the Uluru Dialogue at UNSW.
This year is such an important year for the Australian Constitution because we're being asked to change it. Now, if you want to change something, you really have to know what it is that you're changing. So this podcast series is to introduce you to the Australian Constitution, all aspects of it, to help you when you make your decision about this referendum.
So join us for this 8-part series as we explore the Constitution, the law, the vibe of the thing, and Indigenous issues in this really important referendum year.
And indeed, it's not just the vibe, it's the Constitution.
In summing up, it's the Constitution, it's Mabo, it's justice, it's law, it's the vibe, and no, that's it, it's the vibe.
That was sensational.
So in this session, we're actually going to be looking at the Constitution in terms of what's not in it rather than what is in it, because it tells us a lot about why we need constitutional change, in my view.
Kim, there's only half an hour. We've not got all day.
Indeed. So I'm going to focus, and I'm focusing on the fact that there is actually no mention of Australian citizenship in the Australian Constitution. Now, I should say there is a mention of citizenship itself, but not Australian citizenship. And anyone who can remember the fiascos in 2017 when we had numerous members of Parliament literally dropping off because they were dual citizens will possibly remember this section that I'm just about to read out.
Is it time for my favourite constitutional section of all constitutional sections?
It is indeed.
Section 44?
It is. It's section 44, subsection 1. Oh, you see, I did choose the best podcast partner for anything on the Constitution.
We should have a little fun sound effect for that. Section 44! It's exciting. It's fun. I, just as an aside before we get to that, Kim, I miss the 45th Parliament. Because of all of this. It was the most fun of the parliaments.
It was a hair-raising period of time, I must say, and it did involve me doing a lot of commentary on Section 44.1. And to remind people, if you are a person who, and this is the wording, is under any acknowledgement of allegiance, obedience or adherence to a foreign power, or is a subject or a citizen or entitled to the rights or privileges of a subject or a citizen of a foreign power, then that person shall be incapable of being chosen or of sitting as a senator or a member of the House of Representatives. So we'll come back to that section once I do a further explanation, but essentially it means that if you are a dual citizen, then you are not able to nominate to run.
Of course, Kim,
Yes.
you are forgetting, potentially, the one Section 44 character from 2017 that wasn't disqualified under Section 44.1, which was Senator Bob Day, who was a fiduciary interest.
That's right. So there are 4 other sections
Because of course,
in Section 44. You mean you were thinking of the other ones, Joe?
So I was actually thinking of the other ones because
wow.
despite the attention Section 44.1 gets,
Yes.
there's 4 more, 2 of which have gotten use at the same time as Section 44.1 did. So
they are if you hold any office or profit under the Crown or any pension payable during the pleasure of the Crown. This comes back to separation of powers concepts too, because if you're a member of the executive government, you have to resign from that position before you nominate for Parliament. And another one, which I think is what you were referring to, was has any direct or indirect pecuniary interest in any agreement with the public service.
That was Family First Bob Day.
Yes.
And the last one is you can't be a bankrupt.
That's right.
Which was Senator Rod Culleton of WA.
And then there is actually one more, and I don't know if it's ever been used, is attainted of treason or has been convicted and is under sentence or subject to be sentenced by any offence punishable under the law of a state. Sorry, this probably has been used. If you've been sentenced for imprisonment for 1 year or longer.
Yes, I think that has been used.
Yeah.
But
the treason one, I'm not
bit.
so sure. Yeah. But still, my reason for introducing it, unbeknownst to James here, is actually Section 44.1, because that's the only actual reference to the word citizen in the Australian Constitution. Now, what is really interesting is when we were talking about federalism and that the system of our Commonwealth Parliament sets up certain areas in which the federal government has the capacity to make laws, there was actually a discussion in those 1890s conventions that we talked about with the history of the framing of the Constitution, where they actually discussed. Sir Robert Garran, who later became who was a delegate, who later became an Attorney General, was trying to advocate that one of the heads of power in Section 51 for the federal government to make laws was the laws in relation to citizenship. And it was quite vigorous discussion. And in fact, I've referred earlier to Sir Isaac Isaacs in the history section as being one of the Jewish members of Parliament, or Jewish drafters of the convention.
And later Governor General.
And later first Australian-born Governor General. He said, and the reason his line that I've often quoted is that he said, if we put that into Section 51, it will lead us to innumerable difficulties. So the question is, what were the difficulties that he was alluding to? It's a bit of a rhetoric question here, even though you may know the answer, James, and is that they were discussing White Australia policy. And of course, as we've discussed.
What a surprise.
Yeah, they were motivated by creating this parliament so that they could have uniform White Australia policy. And once you started talking about citizenship as opposed to subject status, because of course, as we've also discussed earlier, at the time of Federation, all those resident in Australia were subjects of the Crown. They weren't actually Australian citizens. But if you started to introduce the term citizen, how would you discriminate so overtly against non-white British subjects, as in those from India or from Hong Kong? And they were quite determined that they wanted to be able to continue to discriminate. So that was quite a significant reason why they didn't choose to put a head of power over citizenship, but rather chose to have a head of power of what's called the aliens and naturalisation power. And little kids, when I talk about the Constitution in a different sort of context for school kids, will often laugh when they hear that there's an aliens head of power.
Yeah, look, I had to stop myself from laughing at that one because it's funny. We do technically have a head of power to deal with ET. It's kind of fun.
Indeed.
But I'm also 5 at heart, so.
Indeed. I think that's coming through this podcast. So,
ouch. A little bit, getting a bit nasty. You've done a few of these now and you start.
Yeah, it's a joy de vivre approach. You see, we can be young at heart and still enjoy the Constitution. That's the message, isn't it? But yes, so they were really concerned. That was one of the reasons. But there were several other reasons why they chose not to have a head of power over citizenship. So one was the immigration discrimination. The other was they were setting up this federal system and they said, it's a bit tricky to work out what would be state citizenship and what would be federal citizenship. So that was another thing they weren't so sure of. The third idea was actually, what does it mean to be citizen? What are the rights that would flow from it? And, think about women who didn't have voting rights or children. We would see them as being citizens, but we don't see them as being entitled to rights. And, of course, on a very significant scale in terms of the Uluru Statement from the Heart, Indigenous Australians were subjects of the Crown but were not subject to the same quality of treatment and were positively discriminated against. So citizenship is
until very recently as well, I might add.
Until 1962.
My grandmother was not born a citizen with the same rights as other citizens, right?
Yes, exactly. She was born a citizen but without the rights. Yes.
So, yes, she wasn't born a citizen with the same rights, say, as yourself.
Yes, exactly.
Which is a very kind of interesting dynamic to think about, that some people who are not of a terribly old age.
Exactly.
My grandmother's in her 70s.
Yes.
Who was not people who are born in the people who were born in the 60s even, who are
Indeed.
not that old necessarily, or if they wouldn't say they were that old, are born without the same equal
formal
amount of
rights. And of course, we'll come back when we talk about the Uluru Statement to think about the difference too between formal rights and substantive rights. The fact that there is no reference to citizenship in the Australian Constitution is reflective of the period in which this whole framework for governance in Australia arose. And part of my argument that we really need to address the fact that there are governance and structural issues that lead governance to be available to be discriminatory. And that's not healthy in a society like Australia, like any liberal democratic society, where you enable those in government to be discriminatory in ways that are constitutionally questionable.
But it is, of course, to be expected, perhaps, Kim, when the document is as old as it is, with very limited change. We've only had 8 changes to the document since
Yes.
1901.
Indeed.
On less than 8 occasions have we had
Yes.
change.
Yes.
So really, substantively, it is basically the same document.
Indeed.
With a few notable exceptions. I'm not discounting the big exceptions that we all probably are aware of, but there's not a lot that's different from the document as it exists now in 2023 Australia.
Yes.
With regards to, and I'm sure you're heading there yourself already, but multicultural Australia in 2023 is very
Indeed.
different to 1893 Australia.
Exactly.
And the kinds of people they could ever have possibly imagined running for Parliament under Section 44.1.
So that's a beautiful segue back to the next point that I wanted to make, which is exactly that we've seen such a change in Australia in terms of the composition of society. So not only recognising the what I would say inappropriate discriminatory framework for citizenship as a way to discriminate against Indigenous Australians or to non-white immigrants, but also in terms of the evolution of a multicultural society. So we did get to a point where the White Australia policy was no longer the policy of the day, and a more inclusive, non-discriminatory policy towards immigration evolved from the 1970s onwards. And we now can sort of very proudly proclaim that over 50% of the country now have a parent or were themselves born outside of Australia. So that means that you have over half the country who practically are being disadvantaged in thinking about what I would call the highest form of citizenship of running for Parliament.
So I don't have that fact about me be true. Kim, is one of your parents born overseas?
No,
or-
so I'm also in a scenario, as I think I mentioned at the very beginning, I'm 6th generation Australian on one side and 4th on the other. So I only actually do hold one citizenship, but I'm so aware in our multicultural society that, that there are a significant number of our fellow citizens who practically are more disadvantaged. And some people say, well, it just means that they have to give up their other citizenship. Well, that actually isn't necessarily always straightforward.
I mean, this sounds to me like a good segue into the Love and Tom's case, which we have discussed earlier in
It is
another
indeed.
episode, because it's a really interesting case, and it's a really interesting thing about citizenship and the changing boundaries of Australia. For those not familiar, I'm happy to give a bit of a background to
Wonderful,
the case because I'm
James.
fairly familiar with it. I think
Yes, I can
you
correct
probably,
anything
you probably
you say.
are as well. So from the 1970s, Papua New Guinea was a colony of Australia.
Before
Was
1975.
a territory of Australia. So people born in there were Australian insofar as you could call them citizens.
Yes.
But when Papua New Guinea gained independence, people born in Papua New Guinea weren't entitled to Australian citizenship. They were entitled to Papua New Guinean citizenship, even though when they were born, they were Australian citizens. And so it
Correct.
creates this circumstance for a fair number of people. It's not a small amount of people. It's a fair number of people who have this happen to them. They were born in Papua New Guinea as Australians, haven't realised that in 1975 that was taken from them, and now aren't entitled to Australian citizenship, or aren't entitled to, or haven't gotten Papua New Guinean citizenship. Of course, that's not, and so that's just the example I'm going to give us some background to this, where you kind of can be a citizen of one or none, or it's kind of the weird statelessness that
Yes,
created.
correct.
Love and Tom case, both of them, I believe, are from New Zealand. Is the case that these, I think, their background.
Right.
But the point being,
So
is
one was Papua New Guinea.
one was Papua New Guinea,
And one was New Zealand. But in
two
any
men
event.
who are Indigenous people, one who's a recognised native title holder in New South Wales, had this situation where they were born in a foreign country to Australian parents, moved here as small children, and then but subsequently never got their Australian citizenship, or in the case of, I believe, one of them lost it due to the 1975 kind of
change in territory.
border kerfuffle with
Yes.
Papua New Guinea. What that results in is they're technically not citizens, so they can be deported, or could be deported, which was the point of the case.
And maybe to just link back in there, because we don't have a citizenship head of power, but we have an immigration power and we have an aliens and naturalisation power. And those are the powers that allow the Minister for Home Affairs
deport
to
people.
remove non-citizens or non-aliens.
So these two men had committed crimes with sentences longer than a year, which enables them to be deported. And they were scheduled for deportation, but they made this court case that as Indigenous peoples, they're protected from deportation as an alien because they're non-aliens. They
That's
can't
right.
be considered foreigners to this country.
So, and to again put it into a constitutional context, the Commonwealth can only remove aliens because it's the aliens and naturalisation power. And so if you're not an alien, if you're a non-alien, then you can't be removed under that power.
So what a science fiction talk for a constitutional podcast. But the point of this court case is they took it to the High Court, and the High Court ruled in their favour that Indigenous peoples cannot be considered aliens under the definition, under the Migration Act.
Even under the Constitution, as a matter of a constitutional law.
So they've decided on the constitutional principle that we as Indigenous peoples cannot be considered aliens, and therefore in the case of these two men and other men that have come before and since who've had these cases decided on the precedent, they can't be deported back to New Zealand or Papua New Guinea because they're not alien to this place. We are not alien to this place. It's a really interesting, I think, it's a really interesting case, even if it's on. I recommend people go look it up and read into it because it's really
we can put a link
fascinating case.
on our project notes,
and
podcast notes.
I talked about it briefly in the separation of powers section with regards to High Court judges and things like that because it was a decision that wasn't very popular with the government at the time. They really wanted to deport these two men.
And we should say that it was a 4-3 split on the High Court too, which is also really interesting in terms of different interpretations.
Shows a division in interpretation.
Yes.
But the precedent does still stand.
It does. And they are non-aliens for the purposes of our Constitution.
Which is a really interesting way to but the way they got there was really interesting. I don't know if you want to talk about the way in which the High Court decided that, because it wasn't sovereignty that was decided that. It was allegiance to Australia that was decided in that case.
Well, this is another aspect of citizenship here in Australia that shows that and I would say this comes back to the fact that we as a nation, or the framers at the time, chose to avoid defining who is a member, because in effect, membership in Australia from the beginning was anyone who was not an alien. So we define ourselves by who we are not rather than who we are. And I think it's been an avoidance of dealing with those quite profound national identity membership issues that is lingering on to this very day, and is another example of the positivity coming from what I believe the Voice and the whole Uluru Statement from the Heart, because this is an active expression of citizenship by Indigenous Australia to say we want to be identified and connected to the nation and the community, and we are exhibiting active citizenship here. You know, that the whole process involved going around and engaging Indigenous Australians in thinking through how do we become connected to this document in a way that recognises Indigenous Australians.
Because the Low and Tom case was decided on these Indigenous people's supposed allegiance to Australia.
As subjects originally of the Crown.
Indigenous subjects, not on, which most people in lay terms, when they hear about the case, they're like, oh, they're non-aliens because of the sovereignty and the connection to the land over 60,000 years, which of course is
relevant. It's relevant.
It's not irrelevant. It is important. And I mean, for me personally, that's the case I'd be making as to why I wouldn't be deported. Not that I'm a dual citizen or a non-citizen.
Yes, you have the colonial structure to protect you.
I have the benefits of colonialism to protect me there, but the argument I'd be making wouldn't be on my allegiance to the Crown. It would be on my sovereign connection. But the point is, that's not what the court ruled on. The court ruled that actually can't be deported because as an Indigenous person you owe an allegiance to the Crown, in a sense.
And I mean, I think the judgment's quite complicated, and Justice Edelman sort of develops this notion of belongers. So I think it tried to push also beyond the notion of allegiance into that sort of recognition of First Nations connection to country.
And of course, I apologise to everybody if they get to the end of this portion and they don't still understand the case, because I also still don't quite understand the case, even though I'm the one who brought it up.
As we said, it's a 4-3 split, but I think it comes back to the central point of this podcast, which is sometimes things that are not put into the Constitution, like citizenship, reflect some ongoing problematic aspects of a document that is meant to govern a country which has never really come to terms with who is and isn't a member of that country. So the language throughout the Constitution is not about citizenship. We've got that reference to aliens in Section 51. But what we see throughout is a reference to either electors, so there's a reference to people who elect members of Parliament, but we also have a reference to the people of the Commonwealth, and we have a reference to residents of states. So we've got these different ways of identifying membership throughout the Constitution, but all as a consequence of really not dealing, in my view, in a positive sense towards membership of the
Even
community.
just the way you described that, already my brain is picking apart the confusion, because you can be a resident of a state and not necessarily be a citizen. You can be a temporary immigrant,
Yes.
or a working visa holder,
Yes.
or a refugee, or a
Indeed.
person on a long vacation. You're here for 6 months to have a little holiday.
Yes.
You could be part of the people of the Commonwealth without necessarily being a citizen either. So
Yes.
the ambiguity of the language
Yes.
creates, even beyond the notion of indigeneity or
Absolutely.
immigration, creates even just notions of, am I a resident? Because if you're resident for tax purposes is a term that we all probably are quite familiar with.
Yes, yes.
You can be a resident for tax purposes but not necessarily be a citizen in this country.
Indeed.
And does that give you necessarily more rights in the Constitution
Well,
if you're a resident?
So in the second edition of my book on Australian citizenship law, there is a whole
What a plug.
chapter on all those different types of rights and entitlements that come from different categories of membership. But
That's Section 44.1, the rights and entitlements of...
Indeed, absolutely. But the last thing that I think would be good to close off this podcast around is around rights and citizenship, because that's the other aspect. But by not having citizenship referred to in the Constitution and only having that sort of negative right that you can't be a member of Parliament if you hold dual citizenship, is the idea of what are the rights that flow from being a full member, whether you call it a subject or a citizen or otherwise. Because we don't have really any express statement of that in our constitutional document. And we saw that again during COVID in a very amplified way when Australian citizens, thousands upon thousands of Australian citizens, were stranded outside of Australia. And through the different heads of power under Section 51 that we've talked about under our federalism podcast, the Commonwealth was able to regulate people not coming back into the country through the Air Navigation Act, not through citizenship issues. And the Air Navigation Act restricted how many people could come in at any particular time, so that, in practice, citizens were not really entitled or able to come back into their country of citizenship. And I was
really interesting segue back to the powers of executive government as well, right?
Exactly, absolutely, in terms of separation of powers, that this was an excessive, in a time of crisis, the executive tends to overreach. And I was raising at the time significant, really that this raised significant questions about what are the limits of citizenship protection. And in fact, there were a couple of Australians who were stranded overseas in that group of multiple thousands of people who engaged Jeffrey Robertson as a barrister who asked me to prepare a brief for him that went to the the Human Rights Committee of the International Covenant on Civil and Political Rights, because there is, under that covenant which Australia's a signatory to, there is a reference to the rights of citizens to live in their country of citizenship. And so a claim was actually made to that committee that Australia was in breach of its international obligations.
It's the international idea of the right to return,
Exactly.
the right that you have as a citizen to return, and also the parallel right of the right against removal.
Well, that's right. And in fact, to take that even a step further, as citizens living in Australia at the time, we were trapped in Australia. We were not allowed. We had to get permission to leave. Now, again, at the time I was saying, countries like North Korea and dictatorial systems place restrictions on their citizens leaving. This is a very unusual decision for a Western liberal democratic state to place.
We were one of the only countries to do that. Even New Zealand, which had strong entry requirements, didn't have
Those exit
requirements.
So I think it really highlights, COVID highlighted, but all these other examples that we've talked about today highlight the problematic notion of not having citizenship referred to in our constitutional document, but also reflect an outdated document in the sense that it was framed in the 1890s. And as you've said, we've only had a few changes. And we'll be doing another whole podcast about referendum and constitutional change. But I think citizenship links back also so profoundly to questions of Indigenous Australians and their experience of membership.
I mean, it shows a number of ways beyond the Indigenous issue, which I'll get to in a second, but it shows the, I think, disconnect between public perception of their rights
Yes.
and the actual rights. That
Reality.
I think most Australians would think they have a right to return and a right against removal and X, Y, Z, perhaps a right to a Bunnings sausage sizzle. I don't know, depending on where you are. But most Australians would have a kind of very broad sense of what their rights as citizens would be.
Yeah.
Right to free speech, right to freedom of religion, which
There is an aspect of
is in the
here.
Constitution in some form.
Yes.
But a lot of those, most of those, don't match up with the actual document itself. Then there's not a mirror to the right to entry, to the right against being kicked out of the country. I mean, the international system has its own framework for that, but
Yes.
we're not. The international law is infinitely more complex.
Yeah.
And perhaps the right against statelessness might be the only one in which
There would
you
be
could
some
argue
way.
that the
Absolutely
government has no
correct.
right to do that in terms of making you stateless. But again, even we've seen with that attempts by the government
Yes, indeed.
to make people potentially stateless
Yes.
with regards to
Citizenship stripping.
citizenship
Which is
stripping
another
and
whole topic we
whole
haven't
other-
talked about here,
citizenship
but is
stripping
also
and
relevant.
terrorism and people who have their
Yes.
citizenship potentially
Oh,
removed.
James, you've reminded me. I should just quickly put in under the separation of powers theme that we've talked about in another podcast that is also relevant to citizenship stripping, because the Commonwealth Parliament has tried, and there are aspects of the Citizenship Act which enable dual citizens to be stripped of their citizenship. But one of the provisions was struck down by the High Court as being unconstitutional on separation of powers principles, because it was effectively the executive exercising judicial power. So anyone interested in that, will put a link to a note in our podcast notes for that point
Now,
too.
back to the kind of Indigenous thing, I think the citizenship thing is really, really interesting, right, in terms of the conceptions in 1893 or whatever, 1898, about what citizenship looked like and what British subject status looked like, and the idea that even in 1898 we were the same. We were the Indigenous people, which is the we here,
Yes.
were the same kind of British subjects as non-Indigenous Australians,
Correct.
non-Indigenous New South Welshmen or
Yes.
Victorians or
Wherever
whatever.
if they were born on country,
If they were born on-
subjects of the crown.
Exactly, born on crown land, and despite the sadness that brings, it was crown land in Australia, the whole continent. So we had the same status, and yet not the same level of citizenship. And even today, which is again the voice to Parliament, I feel like people may be a bit.
No, this is
Folks
the
who are
link
tuning
back
in,
to-
not wanting to hear that, perhaps are getting a bit like, "Where's the law?" I think no, this is
No,
what this is
it's totally
about.
relevant.
Voice to Parliament. It's not about raising our citizenship rights over
No.
other Australians. It's about equaling
Yeah.
our citizenship rights, because for 120 plus years, longer than that, 250 years basically, we haven't had the same level of citizenship rights, even if ostensibly under the British system we were entitled and should have had the same rights and obligations. Of course, I should mention citizenship is not just about rights, it's about responsibilities.
It is indeed.
Rights and responsibilities
Including your responsibility to vote at the referendum.
to vote. Or that's a legal responsibility. The government's going to make you do that one, which is the fun thing to perhaps talk about in another podcast
Yes.
about the mandatory voting that we have.
Yeah.
But this idea that we don't have the same rights. We've never had as Indigenous people the same rights as non-Indigenous Australians. We've never had that. Not in 250 years have we had that. So what this voice is doing is actually seeking to level that playing field.
Yeah.
There's this kind of motto from some in the Yes campaign, which is that it's really about a fair go. It's not about making dividing us on race or making a race-based decision. It's really about leveling the long-term disadvantage that we've faced as quote-unquote citizens, but not citizens.
I like to sort of also remind people about the difference between formal and substantive equality, so that formally, as you've just said, Indigenous Australians were always formal members of the community, but substantively, both in terms of some of the formal laws, but also in terms of the practical application of the laws, Indigenous Australians have not had that same substantive equality. And so we are at a point where we can, through the structures of governance, equalise and enable Indigenous Australians' active citizenship to reflect a more substantive citizenship.
And the second thing I'll add as well, which is not entirely citizenship related, but I think is important to mention in the same conversation we're having now, which is that we still retain our own citizenship and our own inherent rights and cultures and all that. All that still is here.
Yes.
It still exists. We're on Ngunnawal and Ngambri country
right now
having this discussion. It always is going to be Ngunnawal and Ngambri country. It always was, always will be. And that was the same in 1898. It's the same now. It's the same in 1788 and 45,000 BC. It's always been the case. We hear the argument sometimes of, well, why does it matter if we're in the Constitution? Like we had our culture in the 1800s and we have our culture now, and that is correct. I still speak my language. My people speak our language still. Around the country, our languages are still spoken and practiced. But we are in this colonial system, whether we like it or not. The Australian state, the Australian Constitution, with the little green and gold booklets that we carry around, that impacts our lives still.
Yeah.
We do retain our indigeneity and our Indigenous citizenship of our own nations. I'm a proud, Baladu Wiradjuri. Like I am Wiradjuri. But I also live in Australia. And this idea that we shouldn't pursue Australian constitutional change because we are sovereign peoples. Mm-hmm. Look, I get the appeal of that argument. I get why people might or do buy into that argument of, oh, look, we should retain our sovereignty. And one, this doesn't cede our sovereignty. So that's a separate discussion for later. But it also it ignores the reality of the world that we live in. Mm. Like we are citizens of this country, unequal citizens currently, unequal citizens as long as it has been a country to call Australia, but still we are citizens of it, and we should be trying to make that more equal for us.
In a substantive way. In
a substantive way to match the formal way, because otherwise we're not actually achieving change in the circumstances in which we really do live.
And on that note, we will finish today's Citizenship podcast. This podcast was proudly produced at the University of Canberra on Ngunnawal and Ngambri country. Special thanks to Rach White for her production. If you would like to find out more about the topics discussed in this episode, the Australian Constitution and the referendum on the voice to Parliament, please refer to the show notes for some useful links. The theme music for this podcast series is How to Vote by Patrick Hazler.